Nsem-Pii TV nie.
Meduko lawyer Paul Adom Otchere ho. Na wakwako pim ewo one of the TV stations in Ghana. Panoa woni omo kokoshia ye no wagu omonimasi ye pa. Ye nyina yenim case ya ewo Ghana ha eye the removal of Chief Justice ya ewiase afana nyina eka ho asem. Na panoa lawyer Paul Adom Otchere kokoshia omo ewo the TV station no na watim akire mo se eba no law pa dia waje atum anase wonim di pa ewo Ghana ya mamra num ye nyina nim se Daniel Ofoli case no anase Daniel Ofoli petition no and I ndisi ama yuko John the many ma gina so na wodi eye Chief Justice Torkornoo adi on the grounds of stated misbehavior and incompetence was signed stating eye 21 specific allegation editi amame no. Na sansem we enkopi panel no so na panel members no toto papa so na lawyer Paul Adom Otchere lawyer ni panyini odi omotana ho na wo kire omo na wo kire mfunso a John Dramani Mahama watim aye against aye Gertrude Arabaseji Torkornoo abusuanya anya fe na da bia meka no me ba betoatoa menonko na sanse na wo dwudwa nsanum na wo kire de Ghana emra ne se e fa the removal of Chief Justice na was hand history back no na Ghana for ana womo na womote pano no nyina hu say no the ensem a lawyer Paul Adom Otchere ne kano eno ne ensem no mu no kore pa yonko abrana lawyer Paul Adom Otchere sasem we opense mu na wo bia atene ho ase yeba Nsem-Pii TV yenetifo ebeto aso.
Chief Justice's removal. It was based on the Daniel Ofori case.
Yes.
Only. Yes. So why are we discussing the other petition?
No, it was in the Daniel Ofori case. So when you look at the letter, sent to her, signed by the secretary to the president. That not yes.
I think that I have some information that I have to share with Honorable Beatrice. The transfer of the judges. I don't think what you said was actually correct in terms of why the matters were transferred. So the transfer. The cases were with Justice Boansi. That particular case was not transferred. What happened was that she had family trouble, as the Chief Justice said in a press conference. I pulled it out, and had to travel suddenly to USA. Justice Miracle took over her court cases, all her cases, not just Daniel Ofori, as it is the practice. And then the other one, there was another case before Justice Lodo, which is the second Daniel Ofori case. That was transferred to Miracle after the lawyer for EcoBank. Both cases were Daniel Ofori versus EcoBank. Yes. So he applied to the court that the cases be united, pursuant to Order 1, Rule 1, 2 of the High Court Procedure Rule. So to suggest that this was some bias on the part of the Chief Justice,
I never said that. In fact,
you said that Daniel Ofori.
I think the question was trying to make was that Daniel Ofori is very well known to the woman.
It couldn't have been as if it was wrong.
I think what she was doing was to establish the basis that Daniel Ofori couldn't have been influenced by the NDC to do so. In essence, Daniel Ofori was known to the lady or to the woman. And they had some history. She called it checkered history. So that's the point she was trying to establish.
And I made the point.
I'm not saying that the Chief Justice did anything wrong in that.
No, she actually said that
that is her administrative right, and I will not fault her. But it was the basis for Daniel Ofori's petition.
So
it was in the petition. This was referenced. Yes, but that's the point. If this is referenced in the petition, this is nothing wrong. She done nothing wrong. So she should not be found guilty on account of this one.
Yes, I'm not sure she was found on the.
But it is in the Daniel Ofori petition.
But the reference petition had a number of allegations.
Yes,
and not all those allegations succeeded.
So which allegations did the committee find?
There were three.
Excluding
the transfer, and there was another one.
The transfer of
the CJ's recommendation. Those were three.
The recommendation, the one you just read.
Yes, the recommendation. The transfer of one, Mr. Baden.
Yes.
And then
that's the staff of the Judicial Service.
And then the per diem bit.
So these are the three. This one failed.
Yes, this one failed.
Because it didn't
refer to it copiously.
I'm saying that this.
Okay.
So the point was that
you are trying to show the relation between the two.
And the fact that I think earlier you made a point that it did appear that the element of the exam. So she was trying to say that Daniel Ofori is known to the lady, and Daniel Ofori could not have been pushed by the NDC to do so. They are the checkered history.
But that may be the reason why Daniel Ofori's application should have been rejected, because it is clear that you and this woman have a fight and you are trying to take advantage of a certain situation.
Even though he may state other points which may be
but they have 3 applications before them. So before you examine Daniel Ofori's speech, I would have thought that once you know that there's almost like a personal situation, you do not allow constitutional provisions that are created for all and for longevity, that somebody can use his personal dislike for somebody, apply through a constitutional provision. It has to be very carefully looked at.
So that one failed. The personal one failed.
No, the point is that Daniel Ofori, that's the point that Honorable Beatrice is making, that Daniel Ofori and Torkornoo are perennially at loggerheads. If the two of them have been at loggerheads, if they've been at loggerheads in the judicial system, and it's well known that these people are loggerheads, then Daniel Ofori should be precluded from being able to
even though he may raise salient points.
That is why I'm saying that because it is law, it is a living organism. So we will grant a 10% chance that when a who has a personal matter with another,
placed on that should have been lower.
It should have been much lower, because this is a person who we all know. I didn't know, but I'm finding out from those who know that indeed she and Torkornoo have been at each other's throat, including making an application to the Supreme Court for Torkornoo to recuse herself, and the Supreme Court granted it. Not perhaps because they felt that Torkornoo was biased, but they also looked at the history from High Court, and they may have found that, well, it's okay. And Madam was agreed with it and she stepped aside. So the fact that Daniel Ofori is the one raising this issue should give us a bit of...
Are you saying that if I'm a loggerhead with you and you do something that is wrong...
That's what I'm granting 10% to. But we all know how human beings are. So we all know how human beings are. So we all may like to take advantage of power one way or the other. That is why the limitations of power is very, very important. That is why when the Constitution gives a power authority to
anyone, the issue about the Daniel Ofori should not have been treated with a lot of seriousness, because Daniel Ofori may have
a personal interest. Now, whether it's a breach or not, and we are now hearing that during the hearing, witnesses came to testify who all said that this has been happening every now and then. Well, the fact that something has been happening every now and then doesn't mean it's correct. But is it the reason why you remove a Chief Justice? That there's been some sort of breach in her travel policy, or even if she hasn't breached it, that some money that is being looked for around her travel policy, obviously no intention to steal has been found, and that is why we remove a Chief Justice. That's how we want to do it.
Look at it this way. The Chief Justice in the Abronye case, for example, when the matter of paying salaries and some facilities and giving some privileges to the first ladies, etc., came up, she was quite categorical about it, that Article 71 cannot be expanded to include persons who have not been named. So salaries could include privileges, other facilities. Now she is quoting from the terms of conditions of service to say that a condition of service granted this. Meanwhile, she has also said, or knows very well, that the conditions of service could not be placed above, for example, the Constitution, which she has interpreted to say that could not be expanded to include the spouses of the people.
Just conditions of service does not include her spouse benefiting from the travel.
Yes.
It does.
You know what I'm saying?
Is that what she's been accused of?
Yes, but she has said, so benefit for her travels, who pays for the travel, the per diem, etc. This constitute privileges, or you can even say facilities that will come with the office.
Yeah.
So if she's saying that even the president's wife and vice president's wife, etc., cannot be entitled to those facilities and privileges by extension, why should she?
Yes, but that's the point. I mean, are they in the president's condition of service? In the president's condition of service, are we supposed to be paying their wife? If it's part of the condition of service, or are you alleging conflict between conditions of service and the provisions of the Constitution?
Exactly. And she has interpreted that to mean that you cannot expand.
Okay, so here is a case where her conditions of service grants it, but we are discovering that those provisions and the conditions of service run contrary to Article 70 and 71 of the Constitution.
She has interpreted.
And then she had occasion to interpret at the Supreme Court, where she said that when this conflict occurs, the Constitution should reign supreme. Is that the point she made at the Supreme Court? That when there's this conflict between.
That's what she said.
Okay, so that these conditions of service.
She was very categorical.
So if that is so, it means that these conditions of service that all Chief Justices have benefited from. But we are now finding out that it runs counter to Article 71 provisions. And then we are saying that you Torkornoo yourself, you know that already. So when you saw the conditions of service, you should have raised that point and changed the conditions of service so that they will conform to Article 71 and 70 of the Constitution. That's what we're expecting of her, isn't it? That she should have done that. Okay, and for the fact that she didn't do that, and that she traveled and she, as it were, through the conditions of service, breached the 1992 Constitution. That is why we are removing her. That's what we are saying, isn't it? Okay.
And the committee said that constituted an assault on the public purse.
Who said that?
The committee.
Oh, the committee said this constitutes an assault on the public. Do you agree with that? Don't you? Okay, fine enough. I think that's how we want to remove a chief justice appointed under the 1992 Constitution. That's okay.
Well, you see, Paul, the challenge is that until she gave that decision, there was this unspoken rule about...
Was it a unanimous decision of the Supreme Court? Yes, she was one of the unanimous.
She wrote
the lead opinion.
She wrote the unanimous opinion.
Yes, so who are the others on the unanimous? Those who agreed.
I forgot.
It was a unanimous decision.
Yes,
who were the others on the panel?
So let me
because that means they all agreed with him.
Yeah, so Palman was there. So Justice
Palman was there. That's very interesting.
Yeah, so
this is Justice Palman.
Agree with you.
Yes.
We cannot make laws together where you say this and then you say that, oh well, I will not apply the laws I have made to myself. As for me, I'm exempt.
So let me give you the other members.
Yes, and Palman also has the same conditions of service, doesn't it?
No,
he's not chief justice. He's not chief justice.
But the justices of the Supreme Court have very similar conditions.
No, but he's not chief justice. And we don't know.
Do you know whether?
But we don't know whether he has used it. We don't know.
That's very important.
So when we do that yesterday, so Justice Johnson was there.
Does that negate appointment?
Does this just let me
assuming that this court case didn't happen and that we have no record of a Supreme Court decision in which Torkornoo participated where she has said these things, would it have changed something?
I don't know what the committee would have said.
That there's a contradiction because she herself.
Paul, let me help.
That's what the committee has said.
That's
the reason of the committee.
That's the point I'm making. So the committee relied on it. They heavily relied on the Torkornoo's history in Supreme Court decisions, especially this case. So I'm asking that, assuming that case was not there, will they have had something to rely on, or they would have treated all chief justices as the same? And in finding out this decision anyway, are we asking the former chief justices to sort of pay the money back? Is that part of the conversation?
No.
And under the Fourth Republic, it is a significant precedent. But I think it's unfortunate, whichever way you look at it. If the Chief Justice was guilty of the offense charge, it's unfortunate. If she was not guilty and the process was unfair to her, it's even more unfortunate. But as a country with a growing democracy, the issues about conflict in opinion or conflict in philosophy between the three arms of government is really bound to happen. And so in America it has happened so many times, it continues to happen. But the way in which these things are resolved is to use most of the processes provided in the law, but hardly ever to touch that sacred impeachment process. And the history of our own country is clear with that. The first president of Ghana, Dr. Kwame Nkrumah, had occasion to actually dismiss Chief Justice Seyaku Kosa on account of a ruling that the court had given. And it occasioned a disagreement between the president in terms of his view of the matter and the courts that heard it. This had been an attempt, a bomb thrown at the president, and you can understand the president will be quite emotional about that. A bomb thrown at the president. The president's investigations suggested to him that his foreign minister, Honorable Akwaje, and his information minister, Adamafio, were both involved in the plot. And so that would look like a big betrayal. So the president must have been quite emotional about that. The matter went to court, and on account of the evidence before the court, the decision was made by Seyaku Kosa that these two gentlemen were not guilty of the offense. However, others were guilty. The other people were charged. The president was infuriated by that and decided that he will sack, just dismiss. There was no process at the time. Just dismiss the Chief Justice, which he did. And in that constitution of 1960, there were limited powers granted to the president of Ghana to participate in legislation, to make laws. So the Osajifo decided that he will access that process, and then actually went to pass a bill in Parliament, which became law, permitting the president to be able to remove the Chief Justice and justices of the Superior Court of Judicature. in pursuit of this law, the president proceeded to remove some other judges in subsequent situations. So it was clear that the president of Ghana could do so. Many people didn't like it, and it affected the social fiber and the way the democracy was working at the time. Anyway, good or bad, the coup came. So if you look at the 1969 Constitution, which is the constitution that came after the 1960 Constitution, there was actually no provision and there was a provision that said that no one can remove a judge of justice or the Superior Court of Judicature or the Chief Justice and all of that. It was very, very tight in 69 Constitution. The reason was that they were trying to correct this horrendous situation of the first one. Now, in the short operation of that Constitution, there was major disagreement between the executive and the judiciary. The president and the prime minister, who carried executive power at the time, and his people had decided to sack some top civil servants because, as it were, they were resetting. In those days, they call it purging the system, but they were resetting. And the reset took them to remove 658 civil servants. One of them decided that, look, I'm going to challenge this. Salah went to court and challenged it, and it was a big issue. The Supreme Court ruled. In fact, there was a major preliminary application about bias here and there, and it was resolved. And then the big ruling came, and the Supreme Court held that the Prime Minister does not have the power to do so and so. It's offended the Prime Minister, and that always happens. But there should be no discussion of I will remove you when I get you, or it should be a discussion that uses the other remedies, if you like, rather than this very sacred removal. So then the government, legislative and the judiciary is bound to happen, or the judiciary and the legislature. But the way constitutions have operated across the world and the way in which we hold these constitutions, hardly do we talk about we are going to remove somebody. In 1979, the situation was similar. There was a Chief Justice called Justice F.Y. Apallu. But there was a coup d'etat between 69 and 79, and during the coup d'etat, the soldiers, when they come to power, they banish the executive and then they terminate parliament, but they leave the judiciary to work, except that they leave the judiciary to end at the Court of Appeal, often no Supreme Court. So this was the situation in the 79, the interregnum between Champo and Akufo and all that, and then the elections of 79. So Apallu was Chief Justice. The Constitution of 79 said that for the superior judges of the Superior Court of Judicature, a judge who was already a judge, High Court, Court of Appeal, Supreme Court, no Supreme Court, so High Court, Court of Appeal, any judge who was already a judge before the coming into force of the Constitution will remain a judge as if appointed under the Constitution. This was the provision that was in contention in the court. Now, the CPP guys had won the election. They felt that F.Y. Apallu was the opposite. He was UP, and they were not quite sure about working with him. So they thought about getting him out. There was a provision in the 1979 Constitution, Article 124, which is the same as Article 146. So they could have used that process. They knew they could have used that process available to them. But because that process is such that you don't really often touch it, you leave it until it is very, very, very critical to do so. That's why the provision is there. It's not a provision that you tinker with every 5 years or every 10 years. Anyway, so they saw that Article 124 the provision was there, but they didn't want to use it. So what did they do? They decided to find a way in which they can manipulate the transitional provisions and the new constitution. So where the transitional provision says that anybody who is a judge will remain a judge, and Justice Apallu was the Chief Justice, but part of the Court of Appeal because there was no Supreme Court. And the judges who were elevated to the Supreme Court were elevated as if they had been appointed under the Constitution. What did they do? They nominated Justice Apallu for the position of Chief Justice. He was already Chief Justice. He was then nominated again by the President. And the nomination sent to Parliament for vetting. When Justice Apallu appeared at the vetting, he told the committee that he doesn't think he should be here because he's already Chief Justice. Under the transitional provisions, he remains Chief Justice, and therefore he's Chief Justice and part of the Supreme Court automatically. The appointments committee said, well, the President has asked you to come. It's up to you. Do you want to do the interview or not? He said, I'll do it. So they took him through the vetting process. The verdict came and he had failed the vetting. This is the way they tried to go about it. because they wanted him out. They knew that they had Article 124. So they said Akpaloo has failed the vetting. Akpaloo then decided that no, I will take an application before the Supreme Court and ventilate this matter. Eventually, he went to the Supreme Court and he won. And he remained the Chief Justice of the Republic. But this is what the CPP guys tried to do. But they knew that they had Article 124 in their constitution. They could have started the constitution, bring somebody to file an application, refer it to a committee, go under in camera and get him out. They knew they could do that, but they didn't want to do that. Then came the...
But why do you think they didn't want to do that?
That's the point I'm making, that these articles and provisions,
But in our situation, we've touched this particular provision a number of times. Peter Otanderi and all of those.
I'm coming to that.
We've touched it. So.
Yes. So you see, when I say touch it, I mean something that looks like orchestrated by politics. That's really what I'm saying. That if an individual, in the case of the dairy one, it's a different matter. It's not executive or another arm of government, or it doesn't seem that it's politically motivated. It's a completely different matter. On such occasions, you may be able to do it. But I'm also talking about touching it in respect of the Chief Justice, not other Supreme Court judges. The Chief Justice, that one. That's the big one I'm talking about. So that was 79. Then we came to 1992 Constitution, and we imported the provisions of Article 124 into the 1992 Constitution, which is
now as
146. The first major brush between the executive and the judiciary under 1992 was the ruling in 31st. It was a ruling that rubbed Mr. Rawlings on the very wrong side. And it was all said that one judge, a former Attorney General, NYB Adade, was responsible for what was termed the coup d'etat at the Supreme Court, because he led the majority opinion of 5 judges. And it was said that it was he who convinced from Benjamin, who in the afternoon during the conference was still in balance. He was looking left or right. And it was Adade who convinced from Benjamin to become part of the decision, as they put it, against Rawlings. In his sessional address to Parliament in 1994, Flight Lieutenant Rawlings found occasion in the sessional address to berate the judges and almost give a warning. And that is the extent to which he was upset with the ruling. Article 146 was there. They could have occasioned an Article 146 petition against NYB Adade, against other judges, and remove them from the court. They could have done that. But because it is rarely touched, all Mr. Rawlings did was to speak about it in Parliament, in the sessional address. We have to be mindful of the fact, as I'm making the point, that there could be an error of judgment on the part of the Supreme Court. That's very possible. They are not infallible. So there could always be an error of judgment on the Supreme Court. In fact, there are those jurists who feel